year, and a very useful judgment was handed down by the Lord Justices in that case. So what I'm going to do is start with some background to that case and talk about the concept of practical completion. Also going to cover some issues to do with completion under other contracts, and then take a look forward to see how this decision has changed the law, what things you should be thinking about on live projects, and then we'll take some questions which will no doubt relate to, in some way, the current coronavirus. So starting with the history of this concept, first of all, it's one of the most important, if not the most important, issue relating to construction projects, because what it does, practical completion or completion, whichever concept exists in your contract, it draws a line, and it draws a line for many reasons. It draws a line in terms of obviously completing works versus the original contract date or program, or dates if there are sections, or key dates potentially for follow-on works. It draws a line in relation to insurance obligations, so that at practical completion, handover back to a client or site occupier means that there's then a shift of responsibility for the site. It also relates to delay and delayed damages, of course, and stops delayed damages at that point. And it also relates to payment and release of retentions, excuse me, which are often held up to the point of practical completion, or at least half of the retention is often held up to that point. But in the Mears case in particular, you can see that practical completion can have several other consequences. And in that case, it was relevant to the issue of taking a lease, whereby an agreement for lease was entered into, which said as soon as the works are practically complete as developed, at that point, there was an obligation to then enter into a lease to take occupation of the building, which in that case related to student accommodation in Plymouth. So I've put up in the slides there the references to the two judgments and the full references to those cases. Should you wish to look them up, you've got the High Court decision in the TCC, and we've also got the Court of Appeal decision after that. So to understand this concept fully, we start in 1898. Like all good stories, we go back in time. And this is a fascinating case involving Sumpter and Hedges, where there was an agreement between the builder, Sumpter, and Hedges, a landowner, for Sumpter to build two houses. And there was an agreement to build those houses, including materials, for around £550. And what happened was the builder ran out of money, and he half built both of the houses and then left site. And the question before the courts was whether or not A, Hedges had to pay any money for the work that had been done, and B, whether or not any credit should be given for the materials that had been provided and bought. And the courts decided in this case, and this is still good law today, that a party who agrees to undertake and finish works is only entitled to be paid for that work when the work is finished, or in other terms, when the work is complete. So the concept of completion goes back to this principle. And it's clear that under English law, the situation is you don't get paid for work unless or until it is complete. Now, of course, that concept has developed over time, and we now have statutory provisions, including the Construction Act, which entitles a party to interim payments along the road towards completion. But notwithstanding those provisions, this case is still good law today. So it has spurred on, clearly, a whole line of historical cases that relate thereafter to the concept of completion. So the next key decision really in relation to practical completion specifically was the Jarvis and Sons versus Westminster Corporation case in 1970. So by 1970, you've got the JCT contracts coming into the fore in the UK construction market, becoming a lot more popular. And you've got the concepts of design and build starting to develop again. And so this case was about whether or not works for the council were practically complete or not. And the judgment involves comments from two justices. First of all, Justice Salmon. Justice Salmon took the view that completion for practical purposes, allowing the employers to take possession of the works and to use them as intended, was relevant. So there's a clear focus on whether or not there is a sense of utility about the state of the works and whether or not they can be useful to an employer. So the concept starts there, but then it moves on, and Viscount Dilhorn really created the fundamental basis of the judgment, where he said that really completion of all of the works is necessary. And that statement, finding a decision on that basis, really set the precedent for practical completion from that point onwards. So I've described that as the prescriptive test for practical completion, being that all works need to be complete. And indeed, in that interim period in the 70s up to this next case, that was very much the view in construction, that practical means effectively completing all the works. We then get to 1981 and the case of Neville versus William Press. And in that case, Judge Newey, who is the same judge, the younger judge, who was on the panel of 3 judges in the Mears case, later, in my case, in the Court of Appeal, which we'll come back to. But Judge Newey then developed what I describe as the more flexible test. And really, I think the course of practical completion changed at this point. And you can see that Judge Newey changed the concept by making reference to the fact that practical completion will not be prevented where the works have been completed free from patent defects, other than ones to be ignored as trifling. So the word trifling then comes into the vernacular of the construction industry from 81. And you then needed to look at whether or not something that is defective on site is considered trifling or not. And that would guide the certifier as to whether or not the works are practically complete. But the use of a word like trifling in itself is not particularly helpful. What they were trying to achieve was to allow a degree of flexibility or discretion on the part of the certifier, and clearly watering down this concept of all works need to be complete to the point where it's a more flexible test that's being employed. In the meantime, there are obviously a number of decisions made by courts outside of England. And when this particular case, the Mears case, came before the Court of Appeal, it was clear that guidance could be sought from outside of the jurisdiction to see how other legal systems, common law legal systems, have been treating the concept of practical completion and or substantial completion. And it's clear that those concepts do exist outside of England and Wales, but practical completion is less common, substantial completion is more common. But in this case of the Mariner International Hotels and Atlas in 2007, the Hong Kong courts confirmed their position on what practically complete meant, which was that the works have been completed free from patent defects again, other than ones which can be ignored as trifling. So harping back to and very much echoing the decision in Neville versus Press and adopting that position. So there's a degree of consistency there. The next case that I want to mention, because it does get a mention in the Court of Appeal judgment later, is Ruxley Forsyth. Now, in this case in the 60s, there was a question about whether or not a swimming pool had been built in accordance with the contract. The swimming pool was supposed to be 7 foot 6 inches deep, and it was actually built to a depth of 6 feet. So it clearly wasn't deep enough. The idea was that the owner could dive in safely at the deep end. But the question before the courts was whether or not the owner was entitled to a brand new swimming pool, or whether actually what should happen is that there should be some form of nominal damages offered for the loss of amenity, insofar as he had to be a little bit more careful when diving into the swimming pool, not to hit his head on the bottom. And the courts decided that it would have been disproportionate to rip up the whole swimming pool, or at least the deep end, and make adaptations to it, and therefore that he would be awarded damages, but only on the basis of loss of amenity, because it would have been disproportionate versus what was being claimed. And in that case, interestingly, if you go back before the appeal, the High Court actually decided that, in fact, I think the parties agreed that the swimming pool, notwithstanding the fact that it was too shallow, it was still substantially complete. And that ties in with a theme that substantial completion is a more generous concept than practical completion. And those of you familiar with, for example, the ICE form of contract will know that it talks about substantial completion, and that you can have outstanding works, snagging works, defects works that continue post the date of substantial completion. So it's not the end of the story so much, but with practical completion, there seems to be a more restrictive or specific concept in relation to English law, at least. So what did the textbooks say? Well, these were the provisions, the relevant provisions from certain textbooks prior to the Court of Appeal decision, and no doubt there'll be commentary for the next 50 years in relation to this case. But what Julian Bailey said in his construction law case, construction law textbook 2016, he said that works are physically complete or certified as complete, save for minor omissions or defects, and the works are otherwise reasonably capable of their intended use. If there are patent defects in the works that are not de minimis or de minimum, practical completion will not have been achieved. So there's a refinement, there's a bringing together of the different concepts that are at play, starting with the physical works or certified works, save for minor omissions or defects. So it's saying you can have minor omissions or minor defects, but otherwise they're reasonably capable of their intended use. That's the third point. Intended use has now come into play. And if there are patent defects that are not de minimis, then practical completion cannot be achieved. So if there are things that are not minor or not trifling, the same concept, if they're more major in their nature, then ultimately they will prevent practical completion. That was the view of Mr. Bailey. Then we come to arguably the most authoritative book on construction contracts, Keating, and at the time in 2016, the latest version then was saying that construction works can be practically complete notwithstanding latent defects, which makes sense if you think about the fact that you have a rectification period which is commenced at practical completion, and obviously you don't know what exists at that time, so clearly if you don't know about it, practical completion can still be achieved. The certificate of practical completion may not be issued if there are patent defects, and that's more along the prescriptive test line. That's echoing the concept of the case before Neville versus Press, more of a Jarvis type interpretation of the law, which of course still existed and was still very much considered binding up until the recent Mears case. And then practical completion means the completion of all of the construction work that has to be done. Well, that's an almost direct quote from Jarvis. Again, that prescriptive, restrictive test, which says you have to finish all the work. But it did mention that there's discretion to certify practical completion where there's very minor de minimis items of work that are left incomplete. So you can see that Keating summarized the position, but there's some inconsistency there, and hence why the Mears case got so far in the courts, because it was 50 years since the Court of Appeal considered the concept properly. So we get to the case, and it's worth noting that there were a number of parties involved in this case. Mears were the incoming tenant and happened to be the claimant. They'd entered into an agreement for lease with the landlord, who were our client. And then there was also a third party involved, being the design and build contractor. So you had an agreement for lease, and then you had a building contract under the JCT design and build contract as amended. You then had the employer's agent, who were also a defendant, because they had said that they were going to certify practical completion, and indeed they did, but it was Mears's position that they'd done that wrongfully, or that that certificate was invalid. And under the agreement for lease, there was a 21-year lease to be taken upon practical completion, or shortly after, and a juicy annual rent of 1.67 million. So clearly a huge amount of money at stake on whether or not practical completion had been achieved. And the buildings in question were 2 blocks of student accommodation in Plymouth. So looking at the specific provisions, because whenever one is considering what is the definition of practical completion or completion under any other form of contract, the starting point is always the contract provisions themselves. And the key provisions in this case were in the AFL. The first one saying that a certificate of practical completion had been issued, if a certificate had been issued by the 18th of December 18, otherwise known as the long stop date, Mears had to take the lease. Of course, if practical completion wasn't achieved by that date, then they did not. They could give notice to terminate. The next provision, which was relevant, which was 14, clause 14.4, the issue or non-issue of a certificate of practical completion was to be in the sole professional discretion of the employer's agent, Costplan. So sole professional discretion is not a phrase that you'll commonly see in standard forms of contract, which made this situation slightly different. But again, it's important to look at the wording in the contract and the powers that are bestowed upon a certifier. Clause 6.2.1, which was the operative provision in terms of Mears's case, related to making variations. And what it said was that the landlord, our client, couldn't make variations to the works which materially affected the room sizes. And it went on to say that a reduction in size of more than 3% from the sizes shown on the contract drawings, we'll come back to that, was deemed to be material in size. And then in terms of the works had to be practically complete, which was a standard JCT provision with wording that talked about practical completion, but it also referred to other provisions of the contract which had to be satisfied, including within the agreement for lease, a provision that talked about the qualitative standards in the contract being achieved. But ultimately it was a question of whether or not that practical completion certificate was valid, given the argument that some of the rooms were too small. Mears were successful initially in obtaining an injunction to prevent the issue of practical completion. But a condition of that injunction was that there had to then be an expedited trial on the issue of the 3% and whether or not that was enough to prevent practical completion being validly certified. And so there was a trial at the end of 2018 before the High Court, at which Justice Waxman sat. And the case that Mears ran was that the 3% effectively prevented practical completion from being achieved. Mears also sought a declaration that on proper construction, any reduction in room size beyond the 3% was a material breach of contract, which prevented practical completion from being certified. My firm and myself in particular represented the landlord, and our case was that the 3% was not necessarily a material breach of contract. It related to the size of the rooms, yes, but it was a question of fact and degree as to whether or not any such breach could prevent practical completion. Was it serious enough? And we gave examples. If a rubbish bin storeroom was 3.1% too small, it would have no effect on the building. Even the bin store could be used. You wouldn't even notice the impact. And could someone walk away from a £30 million lease on the back of a small indiscretion like that? The answer must be no. And so before the High Court, Justice Waxman found that in fact 56 of the rooms were indeed built more than 3% too small. And there were arguments around which drawings the builder, the contractor, and indeed the landlord was responsible for building. In relation to the contract documents referred to the planning drawings, which were of course issued many years earlier for the purposes of achieving planning permission, and were not an exact mirror of the final design drawings that were produced by way of design development through the design and build contract. And there were arguments over whether or not it should be the earlier drawings or it should have been the final drawings, really. And indeed whether or not there are any variations to those drawings throughout the process. But nonetheless, the court decided that there were 56 rooms too small. However, what he then went on to find is that actually he refused to grant the declaration that the discrepancies prevented practical completion necessarily, because the AFL and the contract simply did not say that. They said that they were material in size, but not necessarily a material breach in their own right. That was a question of fact and degree. And he went on to say that it would actually be commercially absurd if someone could walk away from a £30 million lease on the basis of a bin store that was 1% or 0.1% too small. And that made perfect logical sense. So my client was successful in defending that claim. Practical completion, which was then certified, was deemed valid, dated the 18th of September, and there was an obligation on Mears to then take that lease. Now, Mears weren't happy with that, and they thought that the judge had got it wrong. And so they appealed the decision. And the appeal went before the Court of Appeal in March 2019. And it was an expedited hearing. We're very grateful for that because there were huge financial pressures on the parties at the time. And Mears put their case again to the Court of Appeal, saying that any breach of the 3% size threshold would amount to a material and substantial breach, because that's what they said was what the contract said. And if they were successful, it would have meant that they could have walked away from the agreement for lease and that the PC certificate would have been invalid. Practical completion would not have been achieved. The panel of 3 Lord Justices, Coulson, Newey, who I mentioned earlier, who was the judge in Jarvis, and Neville versus Press, and then Lewison, Lord Justice, all took the view that Justice Waxman was correct. In essence, they applied the more flexible test to practical completion. And what Lord Justice Coulson held was that a breach of contract would not necessarily prevent practical completion. It would be commercially unworkable if every single departure from contract drawings, regardless of the reason and the nature and the extent of the non-compliance, would be regarded as something that could prevent practical completion. And it harps back to some comments by Judge Newey, as he was then, in the previous cases, where he was talking about the difference between something being built in a factory, having factory conditions, and something being built on site, and the fact that there's a larger degree of error and inconsistency on site, which is understandable and normal in the course of building work. And there has to be that tolerance built in, an allowance. And also you've got the procedure for rectification of defects within the rectification period. And to find that any breach prevents practical completion would make a mockery of that, really. So whether or not such a breach was material to prevent practical completion was a matter of fact and degree. You have to look at the facts of the case, the degree of the breach or the seriousness of the defect, and decide whether or not it's something that is fundamentally serious enough to prevent an employer or an occupier from being able to utilize the building for its intended purpose. So Mears's request to terminate the AFL would have been disproportionate. And going back to the case of Ruxley, it was analogous because you couldn't rebuild this building to compensate for these small discrepancies in room sizes. It just wasn't going to happen. And therefore, that wasn't necessarily determinative of whether or not practical completion had been achieved. It was a question of fact and degree. And more importantly, it was a question for the certifier to consider all the circumstances and determine whether it was right and proper in all those circumstances to certify practical completion. So again, we were successful in defending this case in the Court of Appeal on behalf of the landlord. So this being the first case for 50 years on practical completion, it obviously sets a precedent, a very important one. And I've tried to summarize the key points on my slides as to where we now stand. The first point is it's easier to recognize than to define. Practical completion involves an element of interpretation and discretion on the part of the certifier in view of the contractual requirements. Secondly, it's where the works have been completed free from patent defects other than those to be ignored as trifling. That's consistent with Neville and Press, and it's allowing, again, discretion in relation to patent defects, things that you can identify at the date of practical completion that are defective, but that can be either accepted by the parties or can be rectified by the contractor or whomever is responsible. Thirdly, there's no distinction between patent defects and outstanding works. And indeed, many contracts do actually talk about outstanding works at practical completion and after. And in fact, in this case, there was mention of an outstanding works schedule being provided at practical completion. So it was clear that it was anticipated by the parties when they entered the contract that there might be defects and outstanding works as at the date of practical completion. Fourthly, the nature of the defect is a question of fact and degree. And in considering the fact and degree of the defect, one has to look at the ability to use the building for its intended purpose. That's what's relevant. Can it be used for its intended purpose? And considering that, looking at the fact and degree of whatever defects exist, would they prevent practical completion? But that's not determinative of itself. Just because someone can move into a hotel or a house doesn't necessarily mean that the building is practically complete. And Lord Justice Coulson went out of his way to make that point. It's also probably worth mentioning the concept of beneficial use, which parties tend to refer to in construction. It's not mentioned in this case or in the judgments. So it's very much a concept that's grown up outside of interpretation of the previous case law. But it's, I think, now fair to say that that alone is not enough. Beneficial use, it could perhaps be an indicator that a building can be used for its intended purpose, but you still come back to the question of fact and degree as to whether or not that is correct given the defects that may exist. And then finally, the fifth point is the fact that a defect cannot be economically remedied or indeed remedied at all. You were never going to rebuild these buildings just to rectify some small discrepancies in room sizes, but that didn't matter. It was irrelevant to practical completion, and it was good to get the Court of Appeal to agree with our arguments on that as the landlord. So where does that leave us? Well, the first point is that practical completion is a concept in its own right. And this guidance really, and this judgment, it does have wider ramifications, and the way that it's interpreted will influence the way that cases are decided in the future in relation to all types of completion issues. But it is to be remembered that this was a case about practical completion, and in other contracts you have different concepts at play. In the NEC contract you have completion with a capital C, which is defined in a different way. Are the works in accordance with the works information? Are they free from defect? But defect has its own definition too. So there's less applicability, if you like, less relevance in the context of NEC to that extent. And then you have contracts that relate to substantial completion. And I mentioned earlier that substantial completion is a far more flexible concept, that you're expected to have outstanding works and snagging, rectification works. And indeed, the ICE contract actually refers to substantial completion, and those concepts are accepted by the parties from the outset. So the first and most important point is you need to assess what your contract says. Does it have a definition of practical completion, and have those requirements been satisfied or not? And it's then you start to look at these concepts about trifling, de minimis, fact and degree, and use of the building once you've established whether or not there are other contractual arguments which will take priority. Clearly, if you've got any preconditions set down in the contract for practical completion, then they'll definitely be relevant. But they won't necessarily prevent practical completion unless the contract expressly states so. And that's the key point. And I think that's the point on which Mears lost and that we won, which was that if that was the intention, then the contract had to be very clear that those were the consequences of that type of breach. Next, certifiers should be mindful of the actual purpose of the works and the manner in which the contractor has achieved what it was bound to achieve. It's very important that regular reporting is created, that compliance can be demonstrated. Otherwise, you can end up in serial litigation about points where you have to open up works and assess what happened retrospectively, which is all a bit of a headache and obviously very expensive and time consuming. And then lastly, of certifiers, you really should ignore whether or not defect can be remedied. It doesn't matter. Whether it can be fixed or not is not relevant. You need to focus on the fact and degree and whether or not it impacts upon the utility, the use of the building for its intended purpose. So what can you do going forwards? Well, obviously you start with the definition of practical completion and make sure it's appropriate for the contract and for the works. And just because you've got a definition in a main contract doesn't mean it's appropriate for a subcontract. You need to make sure that these provisions are specific to the works and to the job at hand. So please take advice from a solicitor, somebody who understands these contracts and can help you get the right definition for your works. The parties' intentions relating to the effects of defects and variations, importantly, on practical completion should also be expressed clearly. That was, again, probably one of the downfalls of Mears' argument, which was that the contract talked about variations being material and not being allowed, but ultimately it didn't say what happened if they did happen. And therefore, unfortunately, in their case, it didn't work in their favor. And what you ended up with was a breach of contract. But so what? A breach of contract leads to a remedy whereby damages can be recovered, in theory, if they can be proved, but not the right to walk away from the contract, and not in this case, a right to prevent practical completion from ever happening. You must also note that other requirements may be added as preconditions for the achievement of practical completion. So health and safety requirements, O&M manuals, building control sign-off, electrical certificates. If these are things that you require prior to practical completion or at practical completion, then you need to make sure your contracts specify them. Otherwise, I'm afraid you'll end up with a debate over whether or not they're actually required. And then if there are other agreements that relate to the works, so in the Mears case, obviously you had the agreement for lease and the building contract. Often I see contracts with third-party agreements. Are there obligations under those third-party agreements which need to be satisfied before practical completion can be achieved? So it's a case of consistency, really, across all contract documents and making sure that you take advice early on from a lawyer or somebody giving you advice in relation to what you need to anticipate and what needs to be done before practical completion will be achieved. And then finally, I mentioned them earlier, but remember that each project is different and the definition of completion is different under different forms of contract. And there's a lot of variation out there. So that concludes my seminar, and I was now going to take some questions if there are any, and then I think we'll have a roundup from Julie about events coming up in the future.
Okay, thank you, Ryland. Yes, there are indeed some questions. You'll be unsurprised to learn. Okay, question one. What does this mean for contracts with penalties for minimum room sizes?
Okay, so if you have a contract that has clear provisions that state that penalties are payable in the event of room sizes that are too small, for example, which wasn't the case in Mears, then ultimately those provisions, if they are properly drafted and clear, and there's a clear breach by the contractor, then ultimately there will be a remedy available. Now, as to what that remedy is, you can't have a penalty under English law. A penalty clause will actually be invalid. We don't allow punitive damages in this country. So as to penalty clauses and whether or not they're valid, the key case on that is Cavendish Square, which was a joint appeal that went to the Supreme Court a couple of years ago. And it was involving something very close to most people's hearts, parking tickets. And I think that might be the only benefit of the coronavirus, is that I haven't seen so many parking attendants around, but not so many people driving around and parking. But the issue there was whether or not a parking ticket was valid, and that an administrative charge was a penalty where you left your car in a car park too long. And it went all the way to Supreme Court. And what the Supreme Court decided was that actually it wasn't necessarily a penalty. Up until that case, it was felt that something would be a penalty unless it was shown to be a genuine and reasonable pre-estimate of the loss. Now, the parking companies had difficulty showing that, because they couldn't show that they'd lost, let's say it was £50 administration charge for each of these breaches. They just simply couldn't show that. But what the courts decided was that nonetheless, an administrative charge, if it had a reasonable commercial justification, then it would be valid. It would not be a penalty. So what that did was it changed the concept of penalties. And it now means that when you're talking about penalties, so for example, in relation to room sizes, if you have a penalty clause, it can't be a pure penalty. But if we're talking about a damages or liquidated damages provision that says that there's a breach and a value against those breaches, then as long as there's a realistic commercial justification for those amounts, they are likely to be held to be valid. And therefore, a contractor is going to be liable for those amounts.
Okay, the next question is, can you explain what beneficial use is, please?
Yes, okay. So, as I said, this is not something that has a legal definition. It's a concept that I think was created by the construction industry as a way to interpret what the law said about practical completion prior to this case of Mears and Costplan and others. So my understanding of it is, therefore, and that's all I can offer, it is that it's about whether or not an owner or an occupier is able to make use of the space that has been created or the work that has been undertaken. And to that extent, they have the benefit of what has been built or created. But the level of that benefit and the extent of it is not determinative in its own right anyway. So even if you can demonstrate that there's so-called benefit in using a space or a piece of work, it doesn't necessarily mean it's practically complete or complete in any way. For example, if someone's living in a house that's being renovated, it doesn't mean the works are complete.
Okay. We've also got a statement here that I'm assuming you're being asked to agree or disagree with. I think the concept of fact and degree is ultimately compatible with the substance of Sumpter versus Hedges. Save for minor or trifling defects, the contractor still has to complete the original scope to specified content and standards.
Yes, I think that's right. And in fact, Sumpter and Hedges is still good law today. believe it or not, it is still the case that a builder should not be paid for work unless it's complete, unless the contract says otherwise. But I alluded to it earlier. I mean, you have other remedies now, including under the Construction Act, to interim payments. So there is a right to be paid on an interim basis for works that have been completed. And there needs to be recognition of that under a construction contract. So if the parties agree that there is only to be payment made at the end of the works, but those works are for more than 30 days, then ultimately that will fall foul of the Construction Act. And you may find arguments surrounding interim payments coming into play. And therefore, whilst fundamentally the concept of sumpter and hedges applies, and it would certainly apply to a residential occupier, it's not going to apply to the extent that it's inconsistent with commercial contracts. Commercial contracts are going to fall under the Construction Act in most cases, unless they are one of the exceptions. And in those cases, there is going to be a right to regular interim payments, which could be prior to completion of all of the works. So it may well be that there's payment made on account, if you like, on an interim basis towards completion of the works.
Okay. The next one this is quite detailed, so I hope you're listening, Ryland.
Okay.
If a tenant signs up to an AFL to take an office space shell and core, but the landlord installs services in the tenant shell and core demise, and those services are not shown on any drawings, is the likely determination that damages / compensation will be awarded to the tenant to cover the additional design and construction costs incurred as a result of having to work around the services on site to finalise the design and complete the construction fit out? And I have put that on your private question, your private chat box. You can read that through again.
Yeah. Okay. Yeah. No, I think I've got it. So there's obviously two contracts at play there. There's the agreement for lease and the obligation of the incoming tenant to take the lease. And then you've got the building contract. So much like the Mears case, you've got different obligations under different contracts. First of all, in terms of whether or not there's an obligation to take the lease, I think that there probably would be, unless the contract, the AFL that is, expressly states that there is a right to walk away, to terminate the agreement in the event that there is a variation of the nature or an interference, if you like, of the nature that's been described by the question. So installing services, third-party services in the middle of a space for which an incoming tenant was expecting full occupation would sound pretty severe to me. But be careful. I don't think that that's necessarily grounds to walk away. I think that the question actually identifies part of the solution, which is that what would actually happen is you'd look at what the appropriate damages would be, or an adjustment in the rent. And so you would look to value that, obviously subject to what the AFL may say otherwise. And it might well do. It might have provisions that relate to these. I'd be surprised if it didn't, frankly. And I'd be happy to look at it offline if necessary to advise fully. But on the face of it, it seems to me that this would be something that could be managed out. And the last part of the question relates to additional costs. That will very much depend on, again, what the building contract says in relation to that nature of change on site. Assuming it is a change, the contract is possible. The contract says actually the employer is entitled to install services as necessary. May even be a statutory requirement. So I simply don't know. But assuming that these were things that actually weren't foreseen and they are changes, then on the face of it, you'd say, would it be a change to the working conditions, which would therefore represent a change to the scope and the specification and the requirements, which would then lead to a claim for a change or variation to the works. And in relation to that change or variation to the works, the contractor could then claim for additional cost in relation to the design disruption and delay. And that would therefore be captured. And if it obviously cost the tenant more money, then clearly, or the landlord, whoever it is in this setup, who is responsible for the building works, then they would equally be looking to recover those sums.
Okay, thank you for that. Final question is, if there is a particular requirement to be set out for PC, therefore, should these be set out clearly in the employer's requirements? If so, can an AFL be seen to be considered acceptable? For example, agreed GIA and ranges.
So in terms of whether or not provisions will be in the employer's requirements, they can be anywhere. The relevance of where they are is that certain contract documents have priority over others. So, for example, if the employer's requirements say that practical completion will only be achieved where compliance with a particular standard is achieved, but then the contractor's proposals say a different standard, under the JCT design and build, the inconsistency will be resolved under the standard form in favour of the employer's requirements. So one would then use that process of elimination, if you like, of priority of documents to resolve the inconsistency and then apply the appropriate rule. So the requirements are often found in all sorts of contract documents, is the answer. And it will depend on which contract document takes priority as to what you actually have to comply with. In terms of standards, if I understand correctly, I think we're talking about compliance with performance standards or ranges. It would have to be a case of looking at those, working out what they mean, and if there's a specified acceptable range of tolerance, for example, then as long as you're in the range, you're not in breach of contract. But if you're outside of the range, the argument could well be that it's a breach of contract. At that point, the question will be, like it was in the Mears case, whether or not that's sufficient to prevent practical completion. And that would be a question of whether or not the contract specifically says so. For example, it might say, if you're outside of this tolerance, you can't get practical completion. Well, that would be straightforward. You simply can't. But if it doesn't say that, if it just says you need to be within this tolerance, so what if you're outside? In that case, you then have to consider the fact and degree of the breach and whether or not that impacts upon the intended use of the building and whether or not it's considered trifling, or de minimis in that context. And if it is, then practical completion is achieved. And if it's not, if it's more serious than that, then ultimately it would be something that would prevent practical completion. Sorry, Julie, I've lost my sound.
No, that was me, sorry. One last question coming in. Who was insuring the building whilst the dispute was going on?
Well, that's another good question. I've got to be careful because I risk breaching privilege here, but I'm not going to give any specific names, but I think the answer is that, of course, during the works, you have an obligation as a contractor to ensure the works in the building, and at practical completion, that normally transfers over. Now, practical completion was not legally certified because of the injunction. At the end of the hearing, it was then certified, but it was then questioned by virtue of the appeal. So one party would say it has been certified and the insurance obligation transfers, and the other party ultimately would say, well, it hasn't been achieved. The bottom line is that it was between the landlord and the contractor to come to an arrangement to ensure that there was continuity of cover. But either way, there had to be insurance of the building. But technically speaking, of course, on any project where practical completion is certified, it falls over to the landlord to insure the building, unless or until a tenant comes in and they have an obligation to transfer that or take out their own policy.
Okay, thank you for that, Ryland. Thank you everyone for your questions. Thank you for attending this morning. We hope to see you virtually online again soon. The list of our upcoming online seminars will be in the email that comes out with your CPD certificates, which will be out in the next 24 hours. And the recording of today's sessions, they will be available from tomorrow once they've been quality checked. So thank you again and stay safe, everybody. We hope to see you again soon. Ryland, thank you.
Thank you, Julie.